Hey, welcome back, everybody, to Telemedicine Talks. As always, we have your host, Phoebe Gutierrez, and myself, Leo Damasco. And I want to introduce somebody who is going to be a recurring guest. We have tricked her into coming on a regular basis, and I'm excited. We have Brigid Maloney. She is a practice group leader for the law practice of Lipus Matthias. Hopefully, I said that correctly. And to be transparent, she is our legal counsel, but also I think she has a wealth of information and really somebody that we regularly bounce our ideas off of and totally appreciate her candid nature, her straightforwardness, and really keeping personally myself out of hot water. So, Brigid, thank you so much for joining us. I am excited for you to be here and also that you've agreed to be a regular contributor to our program here. So, welcome.
It's my honor. You know, I love brainstorming with you guys. I love every conversation we have. I feel like when the three of us get together, we strategize in great ways. So this is going to be a lot of fun.
Yeah, no, this is awesome.
It's been great getting to collaborate with you on kind of getting creative with corporate practice of medicine, which I think is going to be probably the main topic that we're going to talk about today. Mainly because you're in New York, I'm in California, and California is really doing interesting things in corporate practice of medicine. And I think over this last year, I've realized a lot of my clients or our clients don't understand. And because of that, it's creating just like a ripple effect. And so I flagged it for you. We had some really, really deep conversations around it and just how California really leads the way a lot of the time when it comes to some of these regulation changes. And yeah, I'm excited to jump into it all with you.
Great. Let's giddy up.
Yeah, let's do it.
Well, so Brigid, one of the things that I think is really interesting is a lot of clients will always say, like, I need to comply with corporate practice of medicine. I need the contracts. Give me the contracts. Or I need the physician owner. Give me the physician owner. And like, really, what is corporate practice of medicine and all of its glory?
Yeah, I'm glad you asked because sometimes I feel like clients come to us asking for CPOM compliant documents, but not knowing what CPOM is all about. So CPOM is a principle that is in effect in approximately 30 states. It's the corporate practice of medicine. It essentially means that corporations and non-physicians, non-physician owned entities are not allowed to practice medicine in that state. Two of the most strict CPOM states are your state, California, and my state, New York. And so in our states, plain old LLCs that are owned by lay people cannot practice medicine. They can't employ docs to practice medicine. They can't, if they're a private equity or an MSO type entity, they can't control how many patients a physician may see. They can't control billing, any clinical decisions, clinical equipment, all of those decisions need to be reserved to the physicians that own and run the medical practice. So the point of the corporate practice of medicine ban, which is, gosh, it's over 100 years old here in New York. I suspect it is out west as well. But the idea is that the person making medical decisions about a patient's care has to be a physician whose loyalty is to the patient and not to the profits. So it's lovely working with you and Leo because you're always going to be a physician-led organization. So this really isn't something that you need to worry about, but I think that it's something that most of my clients and most of your listeners need to have on their mind because MSOs and PCs are set up deliberately to legally circumvent the CPOM prohibition.
Yeah, well, and I think one of the interesting things too about it is, the main change that happened in California this past, year, I think it went into effect in January, was really around the restricted transfer agreement process, which was kind of like that agreement that, these MSOs would have to basically say, yes, we're partnering with a physician, but really at the end of the day, we could replace that physician at any point in time if it's not kind of serving us. Whereas California now is saying, no, if you have an agreement that actually puts that control back on you, ultimately you are still controlling the clinical decision making because you could doctor shop, you could do, whatever. But so that's the piece of the puzzle that California has taken a stance. And as I've said, I've had lots of conversations with clients that are almost wanting to do it the wrong way. And I'm trying to explain to them, but like, can't, like the law.
Pulling out the ability for the MSO to retain decision-making on who their friendly physician shareholder is of their affiliated PC kind of pulls the bottom brick out of the Jenga game. It's everything topples when the physician isn't linked contractually to the MSO. Now, the agreements that friendly physicians sign with the MSOs, sometimes they're called stock transfer restriction agreements, sometimes they're called succession agreements, but the effect is the same. The idea is, I'm a doctor, I'm going to sign up to be the shareholder of an entity that you essentially retain control over. And I promise by signing this agreement that I'm not going to sell my shares to a third party without your permission. I'm not going to pull any distributions or profits out of the organization. I'm not going to implement any policies, managerial policies, without you, the MSO's permission. California has curbed the ability to have this contract with the docs, and Oregon eliminated it altogether. So all of the MSOs with friendly PCs need to come up with a new strategy for locking down their friendly physicians in a legally compliant way. If you don't have that agreement in place, that leaves the physician that has all of the revenues of the entire telemed enterprise flowing through that PC's bank account, and that physician can do anything it wants with that company because that physician owns it. He can sell it to a third party without the MSO's permission. He can bring on new shareholders and pocket their investments without the MSO's permission. So it's a changing landscape indeed.
Well, when does that come into account? When do we have to worry about this now? A lot of our listeners are involved in this PC MSOs, and a lot of our listeners are interested in getting into it, right? We get a lot of questions about that, right? And to your point, MSOs that approach our listeners to become their PC owners don't know what the heck they're doing or don't fully understand. So do we have to worry about this now? Is this coming down the line, or is this something that we had to worry about 2 weeks ago?
In California, this is non-negotiable. This is now. And here's why California is special. California just didn't enact a law and all of a sudden this is a problem. California had the perfect storm that three-factor trifecta went down in California. Last fall, they passed the new law that Phoebe was talking about. And then in March, their attorney general submitted an amicus brief in a court case going on in a California appellate court. And that amicus brief wasn't in support of either party, but it was a CPOM related case. So really the point of the amicus brief was for the attorney general to publicize the state's stance on CPOM and how serious they were taking it. And then last month, the California Attorney General announced a settlement that it had CPOM violations by Aspen Health and fined them $2.3 million.
Oh.
And I've got a personal sentimental connection with Aspen Health in general, simply because 10 years ago, when I first got into the world of MSO-PC work, Aspen Dental had just signed a settlement agreement with the New York State Attorney General for CPOM violations. And so my team developed a summary chart of all of the things that were considered the inappropriate practice of medicine that was handled by in this case, it's called a DSO because it's a dental practice, but it's akin to an MSO. And we used that chart to train all of our associates over the past 10 years on CPOM. And we also use that chart in educating our clients on what CPOM is and what line the MSO can cross and what line the MSO cannot cross. So California, those three things happen in very quick succession. The new law, the amicus brief, and then the Attorney General's settlement with Aspen Dental. So there's no turning back. We've got to get this right in California. The good news is everybody who's in the practice of national telemedicine has a unique California PC as part of their portfolio because it's required. You can't take a PC from a different state and foreign qualified in California. So we're recommending that our clients start with their California PC documents, reimagine a new relationship with their affiliated PC, and update the documents accordingly. And then we can get to the other states. Oregon is going to have to happen next. Most national companies don't have a unique Oregon PC, So they're often using a Delaware or a Florida PC that's foreign qualified in Oregon. So once we address Oregon with those clients, we're not just addressing Oregon, we're addressing the documents that impact most of the states where they're doing business.
No, that's interesting. Now, California sounds like, you could deal with that explicitly or separately. But
Yeah.
the approach then with Oregon is, yeah, the MSA is tied into what I like to call the super PC or the parent PC, right? Usually Florida, Delaware, whatever they decide. So if you apply that one rule to that, then what you're saying is it applies to all the other states that are foreign qualified under that super PC.
It can, because most companies use a uniform management services agreement. And the PC, so say you use a super PC out of Florida for most of your CPOM states, it's foreign qualified, everywhere except California and New Jersey. That PC will have one management services agreement with the MSO, and it will have one stock transfer restriction agreement with the friendly shareholder. So if you're going to fix Oregon, that single document applies to all the other states as well.
Yeah, the majority of the states, really the entire
Yeah,
company.
yeah, and I'm thinking, this is where we're new in our digestion of this, but I'm thinking that forming a unique Oregon PC might be the way to go. You don't need a domestic PC in New York or Texas, but many companies have unique PCs in New York and Texas because they're so heavily regulated. I'm considering adding Oregon to that list of recommendations.
Interesting. Now, is it first comes California, Oregon? Are there other states thinking about doing this? I'm sure there are, right? It's like a dominoes effect, right?
Well, they're trying to come up with a method of my take on it, just from like my regulator lens, is like it has gotten unwieldy, right? Like there really are a lot of companies that are operating blindly. Leo, we see this every day. People wanting to
All
start
the time,
practices or large
right?
companies, and they have lots of money and they're doing some interesting things. And me and Leo are like,
Interesting is a
what
funny
was
word to put
what?
at it. There's other harsh
No, Leo,
words that I would
absolutely
put,
not. That is a no go. That is a no go.
right? Shoot, fraud
Um,
maybe. I don't know.
yeah,
But yeah, there's definitely
they're
interesting
trying
things.
interesting things, and again, that's where I go back to, if you have the right partnerships, the best method is you're going to go find a co-founder, business partner, physician to kind of help you build this out and lead the clinical wing, because you need somebody to have that oversight and that kind of experience and not doing it blindly.
And ultimately, isn't that what we want? Don't we want clinicians
No,
running?
it's funny because all these the restricted transfer agreements, so forth and so on, is really a way to legally bypass CPOM, right? But really, CPOM is there for a reason, right? It's exactly like you said. What we want is we want the physicians to lead clinical decision making and not be restricted in any way to do that. So that's funny. That's funny you say that. But again, there's always that business aspect, right? And again, Phoebe, we've run into this a lot too, right? Is that, the folks on the MSO side, the business side with the funds, and I get it, they want some sort of guarantee on their money that the doctor's not going to turn around and run with it without their input or without their say. They want to retain some control, or maybe all control. But yeah, that's the whole point of CPOM. I guess the question is, why don't you just change MSA for everybody? Why don't you just change the super PC, especially if Oregon goes, other states are going to go? Would it just be helpful just to change all that and and not have to go state by state as it goes along in the future?
Yeah, I think that's the best practice. Just do everything correctly. If you're going to go update one batch of documents, update them for the entire country. I just don't know various relationships that companies
Yeah.
have with their friendly shareholders. I don't know that everybody's willing to give up the control over the entire country of their business at once. But it's coming. It's bills on the legislative floor in New York, Texas, Massachusetts, Colorado, Indiana, Minnesota. It's
Cool.
coming. Now, keep in mind, the corporate practice of medicine is only prohibited in about 30 states. So we're only talking about 30 states because the other 20 states, there's no problem there. They don't need a workaround
Yeah.
because lay people can own medical companies.
Yeah, the other 20 states, interestingly enough, they lean heavily on supervision and like heavily on medical director. So the risk is, I guess it's still always on the physician. Interestingly enough, what I've seen in my comparison, and Brigid, I'm curious your thoughts, is like the CPOM heavy states are really on this like ownership side. The other states, like Georgia is not a corporate practice of medicine state, but they are so explicit that a physician has to basically oversee the practice. The physician cannot get paid by a non-clinician for medical to supervise them. It really makes it interesting and tough. But the risk is still on. There has to be this like delegated clinical oversight structure to ensure patient safety.
Right, and there has to be a doctor linked to it. So yeah, you can run the medical practice through an LLC that's owned by an unlicensed person, but the papers that you file with the state still link a doctor and his license to the safety and supervision of that practice.
No, that's super interesting. Yeah. So basically, as this spreads, especially in the CPOM states, the term friendly PC really has to apply. I know right now, I know of a lot of different companies that, the friendly PC, the PC owner is just out there. And really, the MSO doesn't necessarily have a true relationship with that PC owner, working them personally, right? They're just there. And hopefully, they're following the CPOM rules and whatnot. I'm assuming they are. But yeah, there's going to be a lot of trust placed on that relationship, right?
Indeed, there is. And I've always thought it was a relationship built on trust because if the relationship goes sideways, you've got a miserable doctor and you've got a miserable tech company trying to do business. But this is going to amp it up quite a bit more. And I see in you, I'm sure you two have also, I've seen a spectrum of relationships that MSOs enjoy with their friendly shareholders. My favorites are the ones where the friendly shareholder is involved in the MSO's day-to-day business. They know the financials, they know the hiring and firing. They're really involved in it all. They're in regular meetings, they're being reported regularly on finances and business decisions. But there are so many out there also that are just happy to use the physician's license and not check in with that physician much, if at all, other than to pay them. So I think that those types of relationships are going to have to fade away because they just won't work.
Yeah, I think it's interesting because in a lot of relationships that I see with, friendly PCs and MS, yeah, it is. It's a little detached. It's very transactional. I mean, I don't know, maybe it's because I'm also on the very like tip top of the pyramid when I'm, a lot of my clients, I will connect them, of course, with like Leo or a friendly PC that I know personally and would vouch for. That the relationships are kind of starting early on stronger. They're like, able to negotiate contracts together. They're able to have very like open and honest conversations about how to structure the operations. And it doesn't, I don't know, Leo, I don't want to talk for you, but I feel like the past couple relationships that you've gotten to enter in, it really has been, being involved and kind of putting in the work to kind of build that rapport with them.
Actually, yeah, that's an interesting idea that you said that because I've definitely had a spectrum of my experiences with this PC MSO relationships. And currently, now, I have the ability or I have the opportunity to build these relationships with new PCs, new MSOs. And in the beginning, when I started, my first PC MSO relationship, it wasn't that involved. It wasn't, it was more that transactional relationship. And I was just told at the time that, yeah, it was going to be transactional, right? This was how it was sold to, not necessarily sold, but this is how it was explained to me by others that were doing it. That's just kind of what it was. This was in the heyday of COVID, right after COVID, when these tech companies were popping up and they were looking for these PC MSO relationships and they were paying a lot of money to do so. Right. And really one of the selling points as a PC owner is like, hey, you're going to get paid to do this. And it's almost passive, right? And going through, and now I've been doing this for a few years now, this is me personally. I've personally enjoyed getting involved in the company, right? One, it's just, I guess, something I like doing, shopping around, or not talking shop, trying to, help grow the company, so forth and so on, and kind of put my little stamp on the company. But two, it also makes me feel comfortable in terms of CPOM rules. It's that, like, yes, I am definitely involved. If somebody's going to go back and look at this relationship, my name is going to be all over it. Decisions, meetings, so forth and so on. And another thing that I'm finding, and to your point, Phoebe, is that it's kind of a selling point now when I approach these MSOs and say, hey, I'm going to toot my own horn a little, but I could be a value add for your company. I have a lot of experience dealing with multiple different platforms, dealing with payer negotiations, maybe have some connections that you could use. Hire me instead. Let me help you build your company. I guess the approach that I'm using now is, hey, I could be your partner to build this company, instead of in the very beginning, hey, I could be that signature on your, PC MSO agreement to help with the company. So I think people and the MSOs that approach me appreciate that much better. And I think we just have a better conversation.
I agree. I think that having a sophisticated, friendly shareholder can mean everything to a telemedicine company. So I feel like my clients are getting younger and younger as I'm moving along through more birthdays. And so sometimes a tech company will be on the other end of a call with me, and they're kids that just got out of college. They're brilliant. They've got a great business plan. They're funded. So all they need is a doctor to be their friendly shareholder of their PCs. Except these kids don't know anything about medicine or healthcare. They're just investors who have a good idea or wrote some good code for an app that can translate to telemedicine. And those are the ones that most importantly need a sophisticated shareholder like you. And those are the people that don't know it yet, but they will benefit the most from these laws in Oregon and California that will require a more robust involvement of the physician that's in their enterprise.
Yeah, I see that a lot. I think, and Phoebe, we've talked to a lot of different people, on the business side. They're like, hey, I appreciate the docs, the PC owners that have been involved and that are able to talk and guide me through. And funny thing, for the docs that are listening out there who are used to brick and mortar, being clinical monkey who, tries to raise their voice and is just stifled, people do listen to you. They want your input. So, that feeling of not being heard, it kind of reinvigorated I guess, my push to be kind of an administrative side, is because, yeah, actually, a lot of my ideas are being implemented. People take it and actually run with it. So it feels appreciated, which is great.
Yeah. Well, and
Yeah.
the interesting thing where I always kind of come into play is, if people actually, they spend all this money on going to a lawyer and getting everything set up and getting drafted and everybody's negotiating, and then on both sides, nobody knows what the heck is going on. I'm like, if you actually read your contract, like your MSA, it's going to tell you exactly how you need to build your operations. It's going to tell you exactly who needs to review what, at what frequency, and what process. Like, go back, read your MSAs, and make sure that your operational structure is built around that. Because it's honestly not that difficult to operationalize a really compliant structure. People just don't pay attention to the contract, and they will go, and you have, the MSO hiring a bunch of, nurses, and you have an unlicensed person responding to clinical questions in a chat bot. It really kind of cracks me up, because I'm like, guys, like, contract is actually pretty valuable if you just kind of understood it.
So true. Something that happens pretty frequently is I'll get a call from a client who we set up 4, 5, 6, 7, 8 years ago, and they're in hot water with a regulatory authority. And I'll say, well, were you doing it the way that this complaint is alleging you were doing it? Well, yeah. And I said, but that's not how we wrote it in the management services agreement. You're supposed to do it this way. Have you ever read that agreement that we wrote for you? And so it's not just the docs that forget to read it. I think sometimes the MSOs forget to read it, and they very frequently do not operationalize inconsistency.
Oh, it's both part. I mean, that's the whole thing of like, I literally will go through them with people and go, okay, this means you guys actually have to do a background check on providers. That's credentialing. That's a credentialing process. That's what that means. This is why it's important. Like, really kind of trying to break it down, because to your point, Brigid, you have 22-year-olds that are really smart, really intelligent, have got to live, there's that whole, move fast, break things. And my biggest issue in digital health has been, yeah, but we don't do that in medicine. We don't move fast and break things in medicine. Credentialing is really slow for a reason. The whole prior authorization process really meant this. This is what, like, we don't play around with those things, and they're not used to it. They've never worked in medicine.
Yeah, isn't it funny? Telemed is a collision of the tech bros and the doctors, right? The entrepreneurial tech bros and the doctors. And they make nice for the most part, but it's up to us compliance people to smooth out the rougher edges, I think.
And I think for the doctor side, there's definitely times where there's going to be friction, right? And talking with somebody like Brigid, learning how this works, talking to somebody like Phoebe, learning how the compliance works, and really investing time and energy in understanding the steps will give you the tools to be able to present yourself as a good partner and really give you the tools to protect yourself as well, to know when to step away, when to push back, and when and where to draw the line. Because most of the times, right, like Phoebe was saying, is move fast and break things. A lot of times when the MSO side is moving fast, they don't know that things are broken. They don't know they put themselves at risk. And you're going to have to be the one that goes, wait. I was dealing with a kind of a medium-sized telemedicine company, and they were, they didn't have their payment structure all set up. And I had to be the one that was educating them how to set up their payment structure. That's just an example. And it's educate yourself, go out there and understand this. This is no longer just a signature on a paper. So,
well, and interestingly enough, and Brigid, I know we met earlier this week, but I think one of the cool things that I've actually gotten to experience over the past couple months, working on just a couple different opportunities that Leo had, and for people listening, you guys know I help Leo with his compliance, so But the interesting thing is, I've actually been able to get Leo compensated for all the work that it takes prior to starting. So historically, it would be these very long, drawn out processes where physicians would kind of get entangled in it and then not get compensated, because it was always like, well, we'll do it when we get credentialed, or we'll do it when this moment happens, or we'll do it when when we have our first patient. And you're kind of left in this weird limbo. And because Leo's been more involved, I've been able to kind of say, well, it's a consulting fee. I mean, you're meeting with him. He's helping you prior to having everything set up. He's helping you, write your clinical protocols. He's helping you pick your EMRs. He's helping you figure out the payment stuff. He's interviewing your clinicians, because technically he has to. Yep. And he's been actually able to get consulting fees, which are non-clinical, but also, again, I think it's starting to slowly show. I I guess he's dipping into my income, but I'm turning him into a consultant. But to me, I think that's also been really interesting, because I think at the end of the day, if Leo can get more consulting where he doesn't have to be the PC owner, but he could come into these opportunities and actually explain the right process and spend time training companies up, I still think that would even be a huge value add. Because to me, it's, half of the problem, I think, is people just don't understand the right process, because they've maybe had a couple of these opportunities and they were trained wrong from day one, and didn't have a Brigid to like us, who's like, well, you got to do it.
You're so lucky.
Thanks, guys. But I'm glad you brought this up, because that doors open physician consulting is so important. Again, friendly shareholders who are on the naive side of things, sometimes they sign on. The company's already seeing patients. They sort of step in, and there's no policies, procedures, protocols, informed consents, or worse yet, they're working with a batch of documents that were AI'd by the tech company.
Happens a lot.
No
Hey,
doctor eyes on it.
right, here's something that we looked up. This is what ChatGPT said. Can you please sign on the line? Oh, I see your face. We need a video of this, by the way. But yes, it's yeah, right. This is why they need somebody like you, Brigid, to take a look at that. And
Thank you.
it's spend a pound now versus a ton later, right?
Yeah. Well, and again, most of them, which kind of drives me crazy, is they always say, we're going to do compliance at the end. Like, we'll get an audit at the end. I get a lot of calls and emails, but can you come and certify us for compliance? We just finished building our product, or we finished this. And I'm like,
too late. You got to change this, this,
no,
and
I can't. Like, there is no certification. And like, also, I don't really want to, because it's gonna, you've done it completely wrong, because they'll either not have legal counsel, not loop in the right people, not have the right people who understand how it should get formed. And then at that point, it's 3 times more to correct it all.
Yeah, great point, Phoebe. So do we have some takeaways for your listeners? I'm thinking takeaways if you're a telemed company listener, if you're the MSO, open up those documents that you've got, your management services agreement and your succession agreement or stock transfer restriction agreement. They have to be revised or eliminated in Oregon. And if you're a doctor, congratulations, your stock transfer restriction agreement in Oregon is no longer effective. So
you own it all.
have at
right.
it.
Well,
And frankly, one conversation my colleagues and I have had over the years is, what would we do if one of our clients' friendly shareholders went rogue? Because in the backs of our minds, nobody ever really knew how enforceable succession agreements are. It hasn't been litigated. It's an area that is rife. So we now know what would happen if a doctor went rogue in at least 2 states. But I think that many other states, the MSO could find that if a doctor decides to sell the PC out from under them, that the MSO would not have a very strong cause of action to get that PC back.
Yeah, there's been
a lot of good strategy.
Nightmare stories that we've heard on the MSO side with the doctor taking the PC and said, "See you later," right? Yeah. So interesting. Well, hey, we're about time. Brigid, thank you so much. This is amazing. Honestly, we could go on and on and on. One question: how can our listeners get a hold of you if they have any questions or want a legal partner while they go through this, go through their steps? And when I say legal partner, I've really enjoyed our partnership, talking through it, and I truly believe this is a partnership and not just you talking down to me. So highly recommended. But how do they get in contact with you?
Thanks, Leo. I think if you Google Brigid Maloney Health Attorney, I should probably be the first thing that pops up. My email is bmaloney@lippes.com, lippes.com. So those are 2 of the best ways. Or just give Leo a call. He knows how to find me.
Oh, absolutely. It's on speed dial. And you're like one of my little favorites on email. Too easy to find. Brigid, thank you so much. Again, we look forward to having you back on. We already have you scheduled. We got you. Thank you again. This is always a pleasure, but pleasure talking to you over this forum as well.
It's been a lot of fun. Thank you both so much, and I'll see you next time.
Yeah. So our listeners out there, mahalo for listening, and we'll catch you next time.
Bye.
Bye.